SJC-11587, Commonwealth versus Lopes.
Mr. Black, good morning.
Good morning. If you may please the court, Mr. Chief Justice. My name is Attorney Alan Black. I'm from Springfield, actually Northampton, Massachusetts. I represent Mr. Lopes in this matter, case out of Suffolk County. I'm just going to start from the top. I think there are 6 very, very significant issues, and I'm just going to try to do as many as I can in 20 minutes. But the first issue is the Batson-Suarez challenges. I believe that co-counsel actually preserved the issues and the objections and the numbers extremely well. They were all joined by counsel, so I think the record is really clear as to who was challenged and what racial makeup there were and what reasons were given by the Commonwealth. I just want to say that my client was Cape Verdean, man of color. The way this came down was that co-counsel started by, on page 4 of the transcript, started by noting that the first objecting to a 27-year-old black woman, 22-year-old male, and an 18-year-old female minority being challenged. That's how it started. Objected and then put again on the record up to this point a black woman, a Korean, Asian, and a Hispanic or a minority, and then put on the record again 4 out of 6 challenges were minorities.
Do you have the record cites to those? Do you
I
know
do.
where on the
In terms of the
transcript?
transcript pages? Yes, I do. Do you want me to get them right now?
No, not if you don't have them.
I have them in the brief, and they're on page 4, and I can get, and I can.
No, if it's in the brief, that's fine. Thank
Okay.
So
They were,
how do
every
we-
time this happened, there were
Where does, well, let me ask you this question. This
Sure.
is what I was, your sister says one of these jurors' cousin had been prosecuted by the DA for murder. Another had a brother who was convicted by the DA and himself was convicted of drug crimes. Does that get, as we are determining whether or not there is a pattern where a judge is aware of that, is that something a judge may consider in determining whether there is a pattern?
I would say yes, but except that in this particular case, Judge Brady never asked for a race-neutral reason at all, ever, until the very end, until the last African-American male juror that was challenged. Finally, he said, "Okay, now there's a pattern. Could you tell me why the challenge?" And then, without waiting for an explanation, starts suggesting the reason, which of course is prohibited under Burnett by this court, and says, "Oh, it's because he's young." And then he's interrupted, and then the ADA goes in and says, "Yes, youth was the reason."
He doesn't really quite say it that way, does he? He says, he uses the word young in a more elaborate sentence than that, right?
I can read it exactly because I have it written down. He starts to say, no, it says exactly, the judge starts to say he is young, ... He's cut off by the ADA, who then goes...
What's the ...
Because he's cut off. The judge doesn't finish the sentence. And then the ADA says he is young, and young people can't even pick their own classes out. So how can he decide a jury trial?
Well, wait a minute, but before that, defense counsel is the one who points out there's been 4 young black males, and so that she brings it up first, and then he talks about, okay, they weren't all young, you know, there was somebody who was 33, somebody who was 48, so they weren't all young. Okay, I'll grant you, this one's young. I mean, that was the...
Yes, but the judge does say it's the... he basically suggests to the Commonwealth that it's the youth is the reason that you're kicking this particular jury. again, the ... is because it's cut off, and then the ADA, I'll find it. I mean, I'll find it because it appears that we have a discrepancy in terms of...
Well, I mean, I can tell you, I mean, it's on page, I think it's volume 3, page 281 it starts on. Actually, page 280. Actually, page 279, line 11.
Well, I'm not finding it right now, but I do have it. Page, fourth black male, 4 out of 6 black males challenged. Okay. Judge then suggested youth as race neutral. Court ruled. Court ruled at that point. And that's what I have.
So getting back to Chief Justice Gantz's question, though, I mean, if the judge knew before he started to talk about pattern, before he started to find a pattern, that some of these defendants had been previously charged or convicted, could he use that in ascertaining whether or not there was a pattern? And you're saying what as to that?
Well, I would assume that the judge could use that to determine that there was no pattern, but he never asked the...
And you don't know that he knew that. Is that, I guess, my question? Do you know that he knew that?
There is nothing on the record to indicate that the judge did know that. And the thing is, the judge just kept on making findings. There's no pattern, there's no pattern, there's no pattern. Therefore, I'm not asking for any race-neutral reason at all. Okay. So you've got all these challenges, all these objections. African-American, you got women, I think 11 out of 16 women, and he never once asked for a race-neutral reason or gender-neutral reason until that last 4th juror. And then he did ask, he said, okay, and when he asked, that's when this exchange that I can't get the exact wording on took place. So he said, yes, there's a pattern, give me a reason, said youth, denied.
All right, so you're saying the jurors stricken before that?
Excuse me, I'm sorry.
Are you saying that the jurors stricken before that were inappropriately stricken because there was a pattern and the judge didn't make the...
He never ever asked for a race...
I understand that. I mean, so what are you saying as to the jurors that were... I mean, which jurors should not have been stricken?
Well, again, when you have 11 out of 16 women, when you have 4 out of 6 African-American males, when you have numerous Asians, Hispanics, etc., all being kicked, and you don't even ask once for a race-neutral reason, I find that, 1, unusual, and 2, troubling.
But you have, we all have the benefit of hindsight. We know at the end of it, we can look back and determine how many persons were struck, or how many they came in, but the judge is doing this in real time. So when do you say the judge committed error by failing to demand an explanation?
Well, you want me to pick exactly the right one? Probably after...
It has to be, I mean, you're asking us to say that the conviction should be reversed because he failed to do it.
I have never
seen... Tell me when there was error when he failed to do it.
The first group.
Well, the first group.
I mean, the first group.
What does that mean? After which juror? Which juror do you say was the point that the pattern was clear enough that he should have said, Ms. or Mr. Prosecutor, I want you to give me a reason why you struck that juror?
So juror 73, first young black male, no explanation, no pattern. There was no bias, no neighborhood connection whatsoever, okay? He was kicked, they objected, no explanation was asked for.
Okay, so that was the first black juror that happened.
Correct.
And you're saying then that, that when he said, I wish to strike juror number 73, that the judge should have said, I need a reason for that?
Yes.
That was the first black
First
juror.
one. First African American. Now, there have been many women and many Hispanics before that.
But I mean, but there were a number, it was not as if there was only one. I gather there were a fair number of minorities in the veneer.
There were, and there were several seated, but of course we know that that's not the issue, and that's not the Supreme Court standard. It doesn't matter that there's some minority seated on.
I'm not referring to the number seated, I'm referring to the number in the veneer. We have said when there's only one, say, black juror in the veneer, and you strike that black juror, that may be enough for a pattern.
Correct, yep.
But that's not what we have here. So you're saying that, are you saying that upon the striking of the first apparently impartial black juror, that was a pattern then?
There should, well, no, I'm saying that there was a prima facie case, and the judge should have said, what's your race-neutral reason? And didn't. Just said, you know what, no pattern, because, and this is the judge's answer, because there are already African Americans and women on the panel. And that is not a correct statement of law, as Your Honor just pointed out.
Well, it's a relevant factor, isn't it?
No.
Not at all?
Well,
It's not
every time I
dispositive.
answer no for sure, 100%, I know it always comes back at me, so let me strike that. Yes, maybe it's a consideration, except I have to say that it's very, you know, I've read a lot of these cases. I've never seen a case where a judge doesn't even ask for a prima facie, for an explanation in a whole jury selection like this until the very end, and then finally sort of says, okay. I mean, usually in trials, I have this situation where they say, all right, give me a race-neutral reason. They give a race-neutral reason. It's either a thumbs up or a thumbs down. He didn't do it at all until that last juror. So 73, 127, 129 are all for African-American males. And I have to say about 127, just to be fair to everybody, it looks like as to all of them, there were contemporaneous objections. As to 127, I couldn't find one.
The 127 was the one whose cousin had been prosecuted by the DA for murder?
I'm not sure.
Is that,
But I didn't see.
was there any discussion in the record?
I did not
Was there any
see-
objection for cause for any
I
of these
didn't
people?
see an objection to 127 at all, and maybe that's because of that reason.
Does our decision in Commonwealth versus Jones have any bearing on this case?
I'm sorry.
Does our decision in Commonwealth versus Jones have any bearing on this case?
I don't know that case. The last juror was 104. And that's when co-counsel said 4 out of 6 black males were challenged. And that's when he said a pattern. And that's when he said, now I have the page, that's when he said youth may have been a race-neutral reason. And that's when he said, that's when the Commonwealth says college kids have difficulties in deciding what classes they have to take.
Well, I mean, you agree that youth is an appropriate basis to strike.
Well, it's interesting that you asked the question because clearly Attorney Sapaccio raised the objection for every young person under 30. And her argument was, yes, it's not a protected class, except when you have two kids that are young and they are minorities, and you're kicking everybody over a certain age of a minority sort of off the panel, then the question, not everybody, most everybody, the question is, do you have a jury of your peers?
Well, but were they kicking white young people off too, or just minorities who were young?
No, they were, of course, you know.
They were kicking everyone young off.
They were kicking everyone young off, correct. And I think I have the number somewhere, but it was like, you know, basically everybody under 30.
Because you can't trust anybody under 30? Is that the basic?
Yes, you can't.
I thought it was the reverse. I thought it was anybody over 30 you can't trust.
But then when the Commonwealth makes,
You're dating yourself.
when the Commonwealth makes the argument saying, well, you can't have somebody like this because they can't decide what classes they're in. I mean, I kind of find that offensive. I also kind of find that
Maybe offensive, but it's not illegal, right?
it's not illegal. I agree. It's not. This court has never said that age is a basis. You're right. Absolutely right. Number 2. Move on to number 2. Well, also just remind the court that if the court finds that there was an issue under Batson and Suarez, that it is a structural error and the case needed to be reversed. Needs to be reversed. And I did
But
cite,
I'm getting a little, so we were focusing in on when, but you also have an argument, he doesn't find a pattern at a certain point. Justice Brady.
the last one.
And do you find his reasoning not, what is it, genuine, I can't remember the standard, genuine and adequate, or whatever the proper terminology is? He makes the conclusion that it is based on youth, and also that the young man who's knocked off would have some sympathy because of his work at Tenacity, which is, what's your response to that?
I cited that some cases that say, mixed, U.S. Supreme Court cases and federal cases that say mixed reasons are still not sufficient. So if you are kicking somebody off because of age, but there's a reason, an unlawful reason, such as a Batson, such as a reason for race, and it's mixed, that's unlawful as well. Powell, I believe, is the case.
Okay, but I'm confused. Are you saying his reasoning here includes something that's genuine and something that isn't? Or I just want to make sure, because he makes the prosecutor argues that there are two reasons, youth and sympathy because of his community service.
He works in the neighborhood, correct. And I don't find that genuine, no.
But the judge did.
Judge did.
Of course the judge did, yeah.
Okay.
Yes.
And the standard is abuse of discretion?
You do place, I don't know if it's abuse of discretion, but you do place much deference into the judge's decision on that issue.
Okay.
But again, I ask you to look at the whole pattern, for lack of a better word, and see what the judge did the entire jury selection, and see that the judge was extremely just dismissive in terms of all of this, just no pattern, no pattern, no pattern, no pattern, as he keeps on kicking minority after minority after minority, and as he keeps on kicking women after women after women, no pattern, no pattern, no pattern. And I think if you look at that, and you look at it, how can it's incredulous to me that that's a genuine reason, but that's me.
You're about to combine two arguments, the Rosario argument and, I'm trying to remember the other one.
Motion to suppress.
But before you do that, is this all harmless? Because the defendant at some point screams out Holmes something or other with an obscenity. Isn't he essentially saying he's a gang member at that point anyway? So all this very complicated legal analysis from the 8 years earlier, it seems irrelevant.
2 years earlier, and I think there's a difference between him. First of all, there are four different people that heard him say. One says, basically Holmes, some cuss word, and the two other police officers, he just says Holmes. Holmes is an avenue. The statement itself that's made 2 years earlier, he says, I'm a member of the Holmes Street Gang. That is really different than him yelling out Holmes at the time he's arrested.
Really? Why do you yell out
Holmes?
Your street name? Your street address? Do you do that? Hey, I live at, 1058.
I'm just saying, there's a big difference between a statement made at a police station when it's a violation of Miranda rights and Rosario, I believe.
I don't necessarily disagree with you on the law because it's messy, but I just don't see that there's anything to it given his basic bragging about being affiliated with Holmes.
Well, I have a minute left, and I think Your Honor understands that issue, but I want to throw that, you're adding all of this.
It's your time, I don't mean to interrupt you.
No, it's okay.
Yeah.
You're supposed to. But when you add the prior act where you have people on Holmes Avenue that robbed this guy, that committed this robbery, the brother of the victim testified that there were people on the corner that robbed him. The client wasn't there. So you have this prior bad act that has nothing to do with the defendant. There's a case, Acker, AKAR, that says you can't have a propensity of a gang violence alone, and that is completely prejudicial. So you add the Holmes Avenue, you add the Rosario violation, you add a robbery that has nothing to do with this case, that was about 8 years, that was about 5, 6, 7 years old.
But the gang evidence here, there's a killing here of a young kid that's inexplicable. I mean, people don't kill people for, running into them with a scooter unless there's something bigger going on. So isn't the gang evidence different here because it relates directly to the motive?
The motive, the Commonwealth's motive was that they ran in, there's no evidence presented at the case at all that he even knew the co-defendant. The defendant knew the co-defendant. There is no evidence at all that the co-defendant in the entire trial was a member of this gang. There was that scooter incident that occurred. That's the only motive that the government suggested for this killing. And it happened to be that the helmet and the scooter was exchanged, and I argue that it was a mistaken identification case.
Right, but it was your client who, for some reason, chose to identify his gang affiliation at the time of his arrest. Doesn't that suggest that?
He did yell out Holmes Avenue. He yelled it out. But whether he yelled out Holmes Avenue, bitch, whether he yelled out, the statement about the credit, and we skipped over this, the one police officer that said my guy actually held on to the person when the shooting occurred was that Officer Williams, and they weren't allowed to impeach him with the fact that he was convicted of lying under oath and suspended from his duties as a police officer before. So
was he convicted of a crime, or was he found administratively to have?
He was found that he stole a scooter and lied about it, and then administratively.
That he stole a scooter, or that he possessed stolen motorcycle parts? I wasn't.
Yes, and then in closing argument, the government said, "How can you not believe him?" Which, of course, is then vouching for a witness who they were not allowed to impeach.
Okay, thank you.
Thank you.
Ms. Smith, still good morning?
Good morning, Your Honor. Good morning, Your Honors, and may it please the Court. Janice Smith on behalf of the Commonwealth. With me today is the trial prosecutor, Assistant District Attorney Patrick Hagan. We're asking the Court to affirm the defendant's conviction for the first-degree murder of 14-year-old Nicholas Fomby Davis. We're also asking that the Court decline to exercise its discretion under Section 33E because the verdict was consonant with justice. If I could, I'd like to correct a few factual issues. On the record, Justice Budd, I believe you had asked for some cites as to when some of these...
I don't remember what I asked for anymore.
then I won't start with that. I will, however, start by clarifying that the record does bear out that jurors number 129 and jurors 127 both had relatives who were prosecuted by the Suffolk County District Attorney's Office, and that is apparent. I would point the Court to Volume 3 of the transcript, pages 60 to 65 for Juror 127, and pages 65 to 67 for Juror 129.
So help me, I'm going to ask you, if you can, to walk through these jurors, which he claims to be showing of a pattern. So we have juror number 73.
Correct.
Who is a black male.
Yes, Your Honor.
Found to be impartial.
Correct. He was 20 years old, and he was a black male, and it was no secret that the Commonwealth was exercising its peremptory challenges on college students. That was readily apparent.
It was no secret because?
Because it was actually in the record, and I would point the Court to...
Before number 73 or after number 73?
In fact, on Volume 1, page 133, Attorney Scapicchio does her first challenge, and she says, I'm going to preserve objection as to age because the Commonwealth is striking all the young people, and there's a bit of a back and forth with Judge Brady, where Judge Brady says something to the effect of, well, age isn't a protected class. And that's actually, and Attorney Scapicchio concedes that that's accurate. This wasn't a secret that the Commonwealth was striking young people.
So 73 was a young person?
Correct, he was 20 years old.
Okay, so he's a young black male.
Correct.
Struck, but there's nothing I gather about him which would, apart from his age, which would be problematic.
No, there's nothing else in the record about that, but I will point the Court to the fact, and Judge Brady did as well, that at that point, There were 2 black females on the jury and 1 black male already seated on the jury.
That makes a difference?
I think it does make a difference because
Have you read
Justice...
Commonwealth versus Jones?
I have read Commonwealth versus Jones, Your Honor.
In light of that, what do you say?
I think Jones is distinguishable. I think there is, in Jones, I think there's a different set of pattern that wasn't found. And here, I think there was I think the percentages were different, if I'm not mistaken. And I think the court here, Judge Brady, was looking at this veneer as a whole and sees that the Commonwealth is striking people of all races, of all genders, based on their age. And that is not a protected class. And there is no mixed motive, and there is no lumping, which is one of the terms that I think was used during the trial. Turning back to the Chief Justice's question about the other jurors, so that was juror 73. No pattern is found, and I think that is within Judge Brady's discretion, considering the composition of the veneer, which he sees, the composition of the jury as it is seated. And then we move on to juror 127. Juror 127, his cousin was prosecuted by the Suffolk County District Attorney's Office and was serving a sentence for first-degree murder.
Now, how did that come out during the course of, I mean, that's in the record, I guess.
It is in the record, and it's at pages...
Record because of the jury questionnaire or because of statements?
During individual voir dire.
Voir dire that emerged.
Yes, correct.
Okay, so the judge is certainly aware of it because the judge is the person doing the questioning.
Correct. This was before, obviously, we're having attorney-led voir dire. Juror 129, it's the same situation. That juror's...
Juror number what?
129?
127, sorry.
I'm sorry, 127, I would point the court to volume 3, pages 60 to 65. And for
You
juror...
talk very fast, Ms. Smith. Sorry, could you say that again?
I'm sorry. Juror 127
Right.
is volume 3, pages 60 to 65. And that's the person whose cousin was prosecuted by the Suffolk County District Attorney's Office for first-degree murder and currently serving a sentence.
And that was clear on the record before the Commonwealth exercised the peremptory?
Yes. Yes, my recollection of the transcript is yes, it was.
Okay.
So people are coming to sidebar for this discussion?
Yes.
Okay, so then...
And we also had juror questionnaires at the time.
Right. Are those in the record or not?
No, they are not.
Okay, so this all is emerging during the sidebar.
Yes.
Okay, so then 129 is next.
And juror 129, and that's volume 3, pages 65 to 67. Obviously, these two came pretty close in time. That individual's brother was incarcerated by the Suffolk County District Attorney's Office, and that juror had also been convicted of drug-related crimes. And that is also in the record at, again, those pages 65 to 67. So...
Okay, I'm sorry, before we leave, 127 and 129, the Commonwealth does not seek to remove for cause?
No, no, there was no removal for cause. There was a peremptory challenge.
But there was no motion to remove for cause,
No.
which was denied. Okay, so who's next after 129?
After 129, we get to juror 103, who is the juror for which Judge Brady found the pattern. And there, the prosecutor provided 2 non-pretextual, legitimate, group-neutral reasons that were constitutionally permissible, and that is, first, that the juror was a young person. And again, it was no secret that the prosecutor and the Commonwealth was exercising challenges on young people. And he does say that college students don't have difficulty choosing their classes, let alone deciding a first-degree murder. And given the way the peremptory challenges had gone throughout, Judge Brady was well within his discretion to accept that as an adequate reason. But we have more. We also have that the juror's occupation was working with youth in the city. And in this particular case, that's very specific to the juror and very specific to the case. Because at that point, Attorney Scapicchio, who represented a juvenile, the co-defendant is a juvenile, had made it clear that she was going to attempt to put into the record evidence of juvenile brain development as mitigation. This is right before the United States Supreme Court's decision in Miller v. Alabama came out. I think
That
it
was
came out.
already on the record that she was going to do that?
Yes, it was.
Okay.
Yes, it was.
Sorry, and Mr. Lopes at the time of the killing was how old?
20. He was 20 years old.
At the time of the killing?
At the time of the killing, he was 20. Mr. Fernandez was 16.
Oh, it was Fernandez was the juvenile, not
Correct.
Lopes. Okay,
That's correct.
okay.
So this is the fact that the Commonwealth was concerned about how a juror might respond to juvenile brain development was a legitimate concern. And in fact, Mr. Hagan puts on the record, As laudable as this juror's chosen profession is, we're concerned that he's going to rule with his heart and not his head. And that's, again, given this specific case, given what was happening here, is adequate and genuine. We vest very broad discretion in our trial judges to make these decisions of both prima facie pattern, which I think goes to Justice Lank's question about Jones, and as well as whether or not a reason given is both adequate and genuine. And we do that because that trial judge is the person who sees the voir dire as a whole, who sees the composition of the jury as a whole, who can look at the demeanor of the parties and look at the demeanor of the jurors. We're looking at a cold record here, and we're reading words where Judge Brady is seeing how counsel is interacting, is seeing how the jurors are interacting, and that's why we allow our trial judges to have that discretion to both determine when a pattern is proper, and it was not here at this point, or earlier on, I should say, and why we vest discretion in our trial judges to say that this answer was adequate, genuine, group neutral.
But don't you think Jones is basically saying it doesn't take much before a judge should find a pattern?
I think Jones says that. I think Maldonado before it says that it's not particularly weighty, but it's still something that a trial judge should have ample discretion to be able to find. And if you look at the peremptory challenges as they went through here, there is no rhyme or reason. There is no pattern except for age and status as a college student. I went through yesterday in preparing for argument.
Do any young people get through to the juror?
There is, in fact, the last juror seated, juror number 1, is a female who is in college. That was on page, excuse me, I can find the exact site, volume 4, page 42.
And white, black, Asian, any?
The record is not clear. The last name of the juror gives some indication as to what that juror's race may be, but I would not presume what somebody's...
We don't know. So one person was let through who's young, but we don't know anything about their racial makeup.
No, we do not. We do know that there were 7 women and 9 men seated on the jury, that there were at least 2 black females, that was juror 115 and juror 111, and 2 black males, jurors 212 and 134. The record, unfortunately, is silent. I'm sorry, we do know there was 1 white male, juror 50. The record is silent, however, on the racial composition of the rest of the jury, unfortunately.
You said 3 black females and 1 black male.
I'm sorry, when the peremptory challenge on juror 103 happened, there were 3 black females. Attorney Scapiccio actually ended up striking one of those jurors and using a peremptory challenge later after that juror had been seated. So at the final composition, we know of 2 and 2. Unfortunately, we don't know the rest. If the court has no additional questions.
Or just to make sure I understand in terms of, in terms of the exercise of strikes, were they done at the end of the individual voir dire for each juror?
Yes. So what would happen is the juror would come up, there would be the individual voir dire. The Commonwealth always went first and exercised their strike. If the Commonwealth passed, then it was, I believe it was Defendant Fernandez and then Defendant Lopes.
So they were all done before the next juror was called?
Correct, yes. But again, Judge Brady is seeing the entire voir dire as it's sitting in the...
And so he's qualifying them on a one-by-one basis, or they were all pre-qualified?
Qualifying on there were original questions asked at the beginning, of course, but qualifying on a one-on-one basis.
Okay.
If the court has no further questions on the peremptory challenge issue, I will very briefly discuss the motion to suppress it, only to say that I think Justice Kafka has it exactly right. Regardless of whether or not there was a Miranda violation or a Rosario violation, this is harmless beyond a reasonable doubt, given the strength of the evidence that the defendant, and the cumulative evidence, I should say, that the defendant was part of Holmes Ave. He says quite clearly twice during, as he is being arrested, he gives his allegiance or his affiliation to Holmes Ave. That's right, Holmes Ave on the block, expletive, and Holmes Ave, other expletive as well. So even if there is an error, which I do not in any way concede there is, it is harmless beyond a reasonable doubt.
Before you leave that, with regard to Miranda, is it a bar against questioning or a bar against interrogation?
It's a bar against interrogation. Miranda's required when there's custodial interrogation. There was neither custody for purposes of Miranda or interrogation.
Let's put aside, let's assume there was custody,
Okay.
and he wants to ask about getting background information about what's going on in the gang activity, used with regard to a crime that had not occurred at the time of the questioning.
There was no-
Is that something that police can do? I mean, I haven't seen a case where this has happened, so I don't know.
Police can talk to anybody about anything. Whether or not that person chooses to engage is up to them. And the police here, Officer Sarah, was crystal clear during the motion to suppress that Mr. Lopes was free to terminate that interview at any time, and he did.
Okay, but certainly they could not have used that against him in the burglary case.
No, and Officer Sarah's testimony was also clear that they weren't talking to him about the burglary. They didn't want any information about the burglary. This was general intelligence gathering, and that was it.
Well, were they investigating a gang-related crime at the time, or were they just looking to strengthen their knowledge about gang activity, which they assume they had plenty of?
He was a member of the Youth Violence Strike Force, so I think he certainly did have some knowledge. However, what they were looking for,
But
there was a
wasn't
new
a particular crime, a murder or something that they were looking into?
There had been a murder. They were looking specifically, though, for general intelligence about a feud between Holmes Ave and Cameron Street, Cameron Street has nothing to do with this particular case. This was also 2 years before the murder happened. It
Seems like a fine line you're doing. You're asking if you're a member of a gang that's involved and there's a murder that they're looking into between two gangs, one of which is the gang you're asking about. And that's not that's not in questioning about that particular crime?
No, because he was not a suspect in that crime, and that's clear from the record. He was not a suspect in that crime at all. In fact, Officer Sarah on page 162 of the motion to suppress transcript actually called it a debriefing. They didn't consider this at all any type of information gathering about a particular crime for which Mr. Lopes was a suspect. If there are no other questions on that, I'd like to briefly address and if the court has no other questions, actually, before
Before you leave the other one, the Rosario issue.
Yes.
It comes down to like 30 seconds or something?
6 minutes.
Yeah, it's kind of, but the judge doesn't really rely on, he sort of says it's good enough for government work, but doesn't really make a finding that it takes place within the 6 hours, does he?
No, what he finds is that the interview started within the 6 hours, which is the CAD sheet that was entered in evidence during the motion to suppress says that the defendant was placed in custody at 11:04. That's what the motion judge credited. The interview started at 5. So
Is it when you start or when you get the information that matters?
it's when the statement happens that matters.
So the judge doesn't really rely on that, does he?
No.
He sort of throws it in as extra stuff, but.
Exactly. And he doesn't rely on it, and nor does this court need to, because this isn't a situation where Rosario should be implicated, just like this isn't a Miranda situation.
Well, but he doesn't find that there wasn't a Rosario violation or there was one, does he? I mean,
He finds that there was not.
really? Because it's kind of mushy what he does at the end, doesn't it? I don't find a Miranda violation. I don't know what he's doing at the end, but maybe you can tell me. Read me the end, the concluding sentence he's got on that.
The concluding sentence is, and I believe that's going to be at the defendant's appendix, page 43. Although the questioning was not completed before the 6 hours had expired, given the purpose for the questioning and the reason for the Rosario rule, there was no violation.
Okay, so he says, given the purpose and reason, there was no violation.
Yes. And the paragraph above that, he also finds, it does not appear that the statements were obtained outside the 6-hour time period established by Rosario.
Yeah, that's the part that I thought was
I think that's the part
wishy-washy.
that you may have been referring to.
Right.
Officer Williams.
Yes, I would like to,
Was there a conviction or was it an administrative suspension?
and that's exactly where I was going, Your Honor. There was an administrative suspension. There was no criminal conviction here.
And did the jury learn anything about it?
No, they did not. And that was proper because, as this court has affirmed time and again, there is specific incidents of lying and prior bad acts of this nature are not admissible to impeach a witness. And this is not a situation where counsel was prevented from cross-examining or exploring bias with this particular witness. Officer Williams was on the stand for 2 days. There's 2 volumes of transcript dedicated to cross-examining him alone. And the defense attorneys, during their cross-examinations, were able to attempt to attack his credibility and call him a liar, and in fact did so both during cross-examinations and during their closing arguments. So this is not a situation where his credibility was not attacked, where there was an undue restriction on cross-examination.
And was there a finding that he had lied or that he had simply been in possession of stolen motorcycle parts?
There is an allegation. I don't believe there is a finding. There's a finding that he was administratively suspended.
I mean, we do, with regard to forensic experts, we do permit inquiry into findings of shoddy practices or whatever else, where this person is the key witness to the case, sort of, bizarrely close to the killing. I mean, sort of, was he, by the way, in plain clothes or was he in uniform?
Plain clothes. He was driving home from work.
So he was off duty.
Correct. He was actually headed home when he saw something. This is different than the forensic example that you gave, Your Honor. That's directly related to their work, and I don't think that this is, first of all, this is something that happened 5 years prior to the murder, had nothing to do with the murder, and was utterly irrelevant. This would have created a mini-trial. It would have distracted the jury from the issues, and a trial judge has a duty to protect a witness from cross-examination that's simply to harass or annoy, and the defendant at trial, nor here on appeal, has demonstrated any bias that he was trying to get out with this. If there's no questions, I'd like to very briefly, and I know I'm running perilously close
Let's get to
on my time.
the closing. Ms. Capiccio seems to inspire such comments. Many of our cases seem coincidentally to involve her, but did Mr. Hagan
He did
lose
not.
his composure a little bit?
No, I don't believe he did. I believe Mr. Hagan's closing argument was grounded in the evidence. It meticulously marshaled the evidence that was properly before the jury. It employed proper rhetoric, and the words that he used that are challenged here are words that this court has found to be perfectly fine and nothing more than excusable hyperbole. I would point the court to Espada, 450 Mass 687, where it was proper for a prosecutor to classify an argument as ridiculous. There is no difference between ridiculous and farce. They are pretty much the same thing. All he was doing, first of all, he spent a great deal of time actually complimenting Attorney Scapiccio on her talent as a lawyer. What he was saying was that this defense that she was putting forward, that my client is there and blacks out, but yet a third person did it, was in fact an implausible defense. That's all this was, and it was proper.
Was the word sham used?
No, it was not.
Was not?
No, it was not. If the court doesn't have any further questions, I will rest on my brief.
Okay, thank you.
Thank you, Your Honors.